No objection, Your Honor.
Court will permit the same.
Your Honor, I had a hard copy of it. If you need an additional hard copy of the response to the file.
I have a copy. I don't need any more paper for this file. Thank you. This is the matter of the people against Jeremy Kirch, indictment 24270. We adjourn this matter to today's date for argument and decision with respect to the defendant's omnibus motions. The court has received the written motions of the defense. I've now also received the people's written response and also supplemental affidavits supplied by the defense to reply to the people's response. Mr. Babanese, was there anything you wanted to say further in support of your motions?
Your Honor, I would simply rely on the arguments set forth in our papers and just highlight that the requested court determined by hearing or otherwise the voluntariness of the consents to search and the statements. And with respect to the search warrant, I would ask that the court determine whether or not the proper returns were filed or the preservation followed pursuant to the search warrants. I know that I spoke with Mr. Carvel this morning, and he indicated he's going to respond to that in terms of some things that they're locating. Your Honor, I do request that the court determine that the proper notice and use of the recordings from the jail were followed in order to utilize those at trial. And we did submit our basis for the MAP hearings, and the other hearings were consented to. We'd ask the court follow this.
All right, thank you, Mr. Carvel.
Yeah, Your Honor, with respect to the search warrant returns, I do believe those were shared in several different leads, lead 88, 89, 90, and 95. There are search warrant returns, which I believe defense alleged that there were not, so we'll
You're
check.
saying those have been supplied?
Those should have been, I will double check to make sure those were shared, but I do believe those were shared with defense, and those should be in his file.
Your Honor, whatever was that we found shared, we provided, so between Mr. Carvel and I can make sure that the court gets those, if they are. So the court can determine what was filed. Were those files with the court? With the court?
I will supply them upon the request of the court based on these motions for search warrants, and I'll supply the search warrant returns as well, Your Honor.
Thank you. Did you have something else then, Mr. Carvel?
With respect to defendant's affidavit, I don't believe that still entitles him to a MAP hearing. I don't believe that there's sufficient facts alleged to warrant a MAP hearing in that regard.
We rely on our papers, Your Honor, with respect to that.
Do you have anything else, Mr. Carvel?
No, Your Honor.
And as to the defendant's motion for Sandoval and Venimiglia hearings, that motion is granted, and any such information must be turned over to the defense no later than 15 days before the first scheduled trial date. As to the defendant's motions relative to discovery, both sides are reminded of their respective obligations under the CPL and may involve the court if there is a genuine discovery dispute. As to the defendant's motion to suppress statements made to law enforcement, that motion is denied at this time. However, the court will grant the defendant's motion for a Huntley hearing concerning the voluntariness of the 6 statements that have been noticed by the people. As to the defendant's motion to suppress in-court identification testimony, that motion is also denied at this time. However, the court will grant the defendant's motion, in this case for a Rodriguez hearing, as to the 4 noticed identifications based on the people's assertions of those identifications being confirmatory in nature. As to the defendant's motion to suppress physical evidence, that motion is denied at this time. However, the court will grant the defendant's motion for a limited Mac Dunaway hearing regarding the circumstances of the defendant's arrest and any evidence seized incident to his arrest. And that may include the circumstances surrounding the consents to search for the trailer and the F-350, if and how those consents were utilized, and to establish the people's claim that these items were merely towed or abandoned and searched only via the ERPO or a subsequently duly issued search warrant. And based on the defense request, the parties may likewise use the suppression hearings in this case as an opportunity to address the defendant's new claim in his reply papers that he was unaware that jail calls are monitored and recorded. I'm not entirely familiar with the specific call of concern here, but presumably that could be simply established by playing the header on every jail call I've ever heard, which begins with the words, "These calls are subject to monitoring and recording." As to the defendant's motion to have the court review the search warrant in this case, that motion is granted with respect to the waiver and search warrant for the RPOD house trailer, those of the 2019 Ford F-350 truck, and the warrants for the iPhone 10670 Wolcott Hill Road, the infotainment system, and the defendant's blood. The people are directed to provide the warrants and applications and search waivers to this court for review, along with the returns that the people just mentioned a moment ago. As to the search warrants for the blink and ring cameras at the victim's residence, review of the same is denied as the defendant has wholly failed to establish standing with respect to those items. As to the defendant's motion to review the grand jury minutes in this case, that motion is granted. The court will review those minutes in camera for sufficiency, which is to include the legal instructions given, and the people are directed to provide a copy of those minutes to the court as soon as possible. As to the defendant's motion for a change of venue, that motion is denied at this time as premature, and as the defense has not met their burden of establishing reasonable cause to believe a fair and impartial trial cannot be had. However, should those circumstances change, the defendant may renew that particular motion. Let's do a couple of the more unusual motions. The defendant's motion for the court to review, as they put it, any and all video and audio recordings to determine if any impermissible hearsay is contained therein, or whether there are audibility issues. That motion is denied, as there will not be any general pre-screening by this court of all available evidence. First, it is not all in the court's possession. Secondly, it is not this court's job. Counsel may review and bring to the court's attention, by way of an appropriate motion, any materials they have identified and in good faith believe should be excludable or which require an audibility hearing. But it is not this court's function to scour the evidence for you. Likewise, the motion seeking to have this court direct the prosecution to supply the defense with electronic discovery via a compact disc or hard copy printout or some other preferred format is denied as wholly without foundation in the CPL. As for the suppression hearings, I have availability, counsel, beginning July 15th and the remainder of that week, depending on your schedule. 15th, 16th, 17th, or 18th, Mr. Vavanese.
Your Honor, would it be possible for me to check my calendar and get that to the court with respect to?
If you need to make a phone call now, let's nail this down.
That's right now, or do you want me to break?
Whatever you need to do, we're gonna set a date right now.
Judge, then to make, why don't we do 15th is a Monday?
Tuesday. 15th is a Tuesday.
We do the 17th and 18th, and that'll give you time to work things out in that week, Judge. There is.
All right, so I'm gonna give you the 17th at 10:30 a.m. I'm anticipating, just based on the volume of materials involved, that this could wind up taking the better part of the day, so box out your afternoon as well, just to be on the safe side. We'll aim to begin at 10:30 a.m. then on July 17th. Mr. Kirch, I'll have you back then to have your suppression hearings at that time, and then we can move forward to start talking about scheduling the trial. Is there anything further from either side? Mr. Cardo?
No, thank you, Your Honor.
Mr. Vavanese?
Yes, Your Honor. With respect to the audibility and non-hearsay of those that I believe we provided in the thumbnail drive that was attached to our motion. Mr. Carvo, what I would like to reduce it for the court, if we could determine what he plans on using at trial, and then I could bring to the court exactly what it is.
So that's a good conversation for counsel to have with one another to help narrow the issues, but to just say,
Gotcha, Judge.
court, here's some stuff, go through it and figure out what's hearsay, what's not. I'm to step into the shoes of the prosecution and start imagining hearsay exclusions. We're not going to do that. Narrow it down. If there's an appropriate motion to eliminate, I would certainly entertain that.
Thank you, Your Honor, and that's why, with respect to that telephone conversation, I did receive from Mr. Carvel that he has reduced it down. So I will find out with respect to the rest of those, and we'll make that.
And again, it's probably better brought as part of
Gotcha.
specific motion practice so that you can make your arguments and I'm not guessing at what
Absolutely.
what you believe constitutes hearsay, nor as to the people's objections. You should
Some of them
flesh
may
out
have
some
been
arguments
used.
with respect to those things.
We will do that, Your Honor.
Very good.
And Judge, with respect to that notice on the telephone call that was provided to the court, there is that part of it, and that's what I wanted the court to determine. It's connected. A copy is in that thumbnail drive that lists the exhibits. The only other issue I had is I know that there's a case pending in the Court of Appeals now with respect to not only notice of use of that recording, not only notice of recording of that statement, but the use of it after that. And so that's why I wanted to preserve the record with respect to that.
And you've done so, and as I said at the suppression hearing, I'm going to give you an opportunity to flesh that out as well. What exactly was or wasn't said and the legal effect of the same. And if after the fact you want to issue me a memo of law in support of your arguments that perhaps you believe that should be excluded, I'll certainly consider that as well.
Appreciate that, Your Honor. Thank you.
I'll have everyone back then July 17th at 10:30 a.m.
Thank you, Your Honor. Just, could we approach for one moment?